And now, AM 650 presents your source for leading-edge news and information on today's hottest products and services. This is Experts on Call on AM 650.
Well, good evening, Happy New Year, and welcome to Key Pacific's Talk About Strata here on AM 650. I'm Stirling Fox. My co-host, as always, is the Executive Director of the Condominium Homeowners Association of BC and Vancouver Province condo columnist, Tony Gioventu. Nice to see you.
Nice to see you, too, and Happy New Year, Sterling.
Well, thank you very much. We both survived New Year's Eve and all of those treacherous spots. You don't look too much the worse for wear. So we're going to do a bit of a re-look, a year in review kind of thing, even though we've crossed the threshold into the new year. There's a lot of new stuff coming down in 2014, but so much so, Tony, that it bears taking a look back for a couple of minutes at least in terms of strata and condos across British Columbia and see some of the movements in that area, that sector, that occurred in 2013, and there were quite a few.
Yeah, and there were a lot of them introduced in 2013 with legislation. It started back actually in 2009. We had an amendment called the Strata Property Amendment Act, and that started the ball rolling and triggered a number of things that were happening down the road in the future. And a lot of those regulations were things that have occurred, things that were enacted. We had depreciation reports that had a 2-year window that basically everybody had this amnesty period for 2 years, right?
Now that's over now.
Back December 13th was our compliance date, and so some things have changed around that we need to talk about. We had changes around parking and storage lockers on disclosure with respects to January 1st of this year. So, and that's a big thing. And we had a new little regulation just before Christmas that came into effect that has an impact on stratas who can't pass their resolutions to get repairs done.
Oh, okay. So where do we start first? Let's start with the most recent, the one that's 2 or 3 weeks old, about strata councils and strata groups and getting things done.
So let's take a typical example, roof. We've got a roof that needs to be replaced. Okay. It's an older building, and the owners don't have enough money in the contingency fund, so they have to vote on a special levy. Characteristically, if it's a building that's had opposition towards raising strata fees or money, the vote will probably fail the first time, if not the second time. Certainly, I was around before Christmas dealing with that, with a number of meetings where it was the 5th or 6th meeting where they were meeting, trying to get resolutions passed, and they can't get them passed.
And the resolution is that they're trying to raise or decree a certain amount of funding from every owner in the place in order to effect a necessary repair. This isn't whimsical by any means. This is an urgent, in some cases, repair.
Well, exactly. We have, the column just before Christmas is just a perfect example of that, because what we're dealing with is a large community of people that can't get a resolution passed, and what the outcome is one person invariably is influencing the control of what everybody's doing. They simply can't get the vote passed for the levy.
Well, from the point of view of those listening right now, and I know that you dealt with in the paper a couple of weeks ago, but it was all based on an email that you had received from Jillian in Vancouver, and she says, if you don't mind, Tony, I'll just quickly whistle through this because this is important stuff. Our strata corporations, says Jillian, have tried 3 times this last year to pass a special levy for the replacement of our roof. We're an older building, do not have significant reserves in the bank to pay, so we're forced to have a levy that will cost each owner about $4,000. One person always shows up with at least 35 proxies to vote against the resolution. So, of the 100 units we have, and the common property that will certainly have a significant impact on our costs, we're told by a lawyer that we may have to make an application to the courts for the appointment of an administrator because they keep getting outvoted, Tony. Basically, that's the whole point.
On and on.
So meeting after meeting, even though there is a group of responsible owners, not happy, I'm sure, in the least, about coughing up $4,000 to fix the blinking roof, but it's their roof. They get it. And there is enough of a voting majority by someone with proxies to block it time after time after time. The roof isn't getting any better. In fact, it may start to leak any minute.
Actually, it is leaking.
So, okay, so now Jillian sends you this, and what consolation did you have, if any, for her?
Well, there's a few options now, and I think one of the things that has changed with the depreciation reports was also the ceiling on how much strata corporations can put in their contingency funds before they need a 3/4 vote. So up until the regulation change a year ago, what happened was if you had an annual budget that was $90,000 for your strata, when you got more than $90,000 in your contingency fund, you needed a 3/4 vote from the owners to collect more money to put in that fund. Well, that regulation is gone. That part of the legislation is retired.
Okay.
There is no limit now. It's now simply part of the annual budget by majority vote. You decide each year how much you're putting in contingency.
And just
so
each strata council gets to determine its kitty, its reserve.
well, the owners at the AGM will make this decision by majority vote, and it's a simple majority vote. And the strata corporation now is in a position that if we know in 5 years from now we need $300,000 for a roof, and we only have $200,000, we can put enough money more each year so that we're not faced with a special levy, because special levies are a real hardship for people.
And if you've got 5 years to raise $100,000 from 100 different owners, that's not going to impose a lot of pain on any individual, especially phased in over 5 years. It's doable.
Well, so the depreciation report gives you this little window into the future, right? Take advantage of it, start planning for it, because this is what happens when you have to have special levies that are significant. If this was a special levy of top-up money of $800 a unit just to be able to top up the fund for the repairs of the roof to be able to finish the work, I don't think this would be a problem. But $4,000 is now looking like a problem.
Sure.
So what does the Strata Corporation do? Well, they do have a few choices. It's interesting to note that of their 3 buildings or their 3 meetings last year, they had lawyers and consultants at every one of their meetings. They spent over $25,000 just on meeting notices, lawyers, consultants on these 3 meetings. Then we moved to damages. They've been doing emergency repairs. They've had insurance claims. They've had damages to strata lots. They're paying for those in addition. Like, they're wasting all kinds of money that could have been avoided had they just fixed the roof in the first place. So, that's another reason why you need to plan for the future on this stuff.
And another reason, because Tony and I always spend a few moments on each program talking to people who maybe for the first time in their lives are looking at a strata lifestyle, moving into a condo, getting out of that big old rambling house in the burbs now that everybody's moved out, and downsizing into something more comfortable. And so one of the things that as a shopper for a strata environment that you need to learn and learn about quickly in terms of asking good questions before you sign on the dotted line is, how about that depreciation report? If I buy apartment 214, how much money am I going to be on the hook for, in addition to my mortgage and my strata fees, for all of this contingency money? And that has to be made available to a potential buyer now, doesn't it?
Well, as of January 1st this year, that became part of the information certificate. So when you purchase in, you are getting a copy of the depreciation report. And it tells you, it gives you a good estimate of the major projects, when they're anticipated to be on the horizon, what the cost will be. It does a profile of the strata's money, so you know how much they have and what the anticipated future depreciation or cost will be. So, it gives you a heck of a lot of information. But going back to Jillian for a second, they have a few choices. They can go to court for the appointment of an administrator, but it's onerous and it's a significant cost, and you will pay for the administrator time while they're on the job while this project is done. The administrator may be walking you through more meetings, maybe more court applications to order the repairs. Another form you can do is, rather than administrator, there is a method called a Tadison order. It was a court decision a few years ago where there was an application to order the repairs, and the courts can simply order the repairs. So that's another option. But again, a fairly lengthy court application. Or we have this new regulation, which now says that if a matter is relating to raising money for the purpose of maintenance or repair of common property, and a 3/4 vote fails, but more than half of the people at the meeting have voted in favor of the vote, they can simply make an application to the court to order the vote.
Oh, so the proxy dance may not be successful anymore.
Well, the proxy dance itself may not only be unsuccessful, but the persons who are representing the naysayers may find themselves on the wrong side of court application now too.
Interesting.
So there are going to be some consequences and some liabilities for this. Best solution, get your building fixed. But every time we look at one of these buildings that has had, sequential meeting after meeting after meeting, sometimes 2 or 4 years later, and they're still meeting about these repairs and things.
Right.
And the damages have deteriorated so much to the buildings that they're paying 50 to 100% more for something they could have just fixed in the first
Well,
place.
and that's your point, isn't it? I mean, the longer you delay, for whatever reasons, maybe it's cult of personality, disagreements between residents, whatever, but every time you set it back, you're increasing your costs.
Every time.
It's just going to get more costly to fix the thing that's already a problem.
Yeah. That being said, there are some buildings that are 30 to 45 years old, developments across the Lower Mainland, that are models of efficiency, upgrades, financial planning. There are some beautiful properties around the Lower Mainland and the Lower Island where people do an amazing job of planning. They
Right.
maintain their properties well. They have reasonable reserves. Their strata fees are well placed, so they're not high, they're not low, but they realistically reflect what people need. And the other side of that is when you look at these communities, there are very few conflicts. They're the interpersonal conflicts because there aren't money issues. What do people fight about? Money.
Money, of course.
Right? Families fight, they fight about money.
Right.
People fight about money, that's all they ever fight about is money. And strata corporations are families, just families full of in-laws, that's all. So that's what they fight about. Get the money issue resolved and protect your property, and you'd be surprised at how much happier your strata community is going to look like.
Okay, in terms of planning and details, and you've mentioned this already, and I want to come back to it because not only from the perspective of the potential first-time strata buyer, Tony, but for anybody in any strata environment, this whole business about parking, stalls, and storage lockers. There's just endless confusion. I bought apartment 214 and the realtor told me they had 2 spots. So I bring my 2 cars in on moving day and somebody just said I've only got 1 spot. I thought I paid for 2. What's going on?
Or
That's pretty standard, isn't
you
it?
look at the listing, and the listing says
2
parking
spots.
parking space 56, 57.
Right.
In most cases, it's fiction. I would say. People are representing what they think they have,
Right.
and that they think they might have an exclusive allocation. They may or they may not. And there are a variety of ways of having parking allocated exclusively, but in most cases, parking is generally common property administered by the Strata Corporation.
Okay.
We have some quirky little things in there, though, that complicate it. Things like owner-developers, when they develop a project, will lease or license parking. So when you go in and you bought, the penthouse 4,
Right.
and you negotiate with the developer says, well, I'll give you an additional 2 parking spaces for $10,000 each. It's a pretty good asset when you think about the value of real estate.
That's right.
So people do that, right?
And if you can afford penthouse 4, you can probably afford 20 grand for a couple more parking spots.
Absolutely. But
Right.
what have you actually bought?
Right.
In most cases, you actually haven't bought anything. You've just simply given money for an assignment of a space that's common property. So that's, in most cases, that you can't buy and sell common property, right? So the developer's not selling you that. What they're doing is they're entering you into an agreement that assigns the space. So go fast forward. Take a couple 100,000 of these owner-developer agreements.
Okay.
And they're everywhere. They're all over the province.
Sure.
I think I'm conservative in saying a couple 100,000. Most buildings have them. You move forward and you're a buyer in 2014. You have no way of knowing which parking spaces are assigned to whom or how they're allocated.
Right.
Except now, our Form B, our information certificate, now wants the Strata Corporation to disclose to a buyer how the parking is allocated.
Oh.
So if I'm looking at Unit 405
Right.
and I make a Form B request with respect to Unit 405, the Strata Corporation now has to tell me what kind of property is it? Is it part of the strata lot? Is it limited common property? Is it common property? Is it part of a reciprocal agreement with another property? How is the parking allocated? Which parking spaces do I have allocated to my exclusive use?
Right.
So, the same applies to storage lockers, too.
But does that mean that, I'm just trying to sort this out in my head, because the allocation of a parking spot to an apartment in the building does not necessarily mean that the owner of that apartment also owns that parking spot, does it?
It almost generally means they do not own it.
Aha.
You almost never own it unless it's a strata lot. If it's part of the strata lot, if it's limited common property, property assigned under an owner-developer lease or license or a reciprocal agreement, it's owned by someone else, but you have some sort of exclusive agreement attached to it.
So parking
and that's
spot,
just as binding as if you owned it anyhow.
so
in
a
most
parking
cases.
spot and a storage locker are essentially the same in that context.
They are essentially the same. And we actually do have buildings in the Lower Mainland where you buy your condo and then you buy your parking spaces separately. They're in a separate strata corporation.
Oh,
right?
Okay.
And so you actually physically own your parking space, and you may own your storage locker attached to your parking space as well.
As is the case in some commercial stratas where you own your law office and then downstairs you own your parking spot.
Could be. But
Okay.
in some commercial offices, you own your law office, but the parking is also common property. So every strata corporation is different. So what you have to do, so you're looking at this form. The new information certificate came out January 1st.
Right.
And it says how parking's allocated. As a buyer, exercise some caution, though. Still look at the registered strata plan. Look at the bylaws. Find out if the owner-developer ever created leases. It's interesting because what we're seeing now is quite a funny little domino effect in stratas, because for the first time, this is not only about buyers now. This is also about, I live in a unit.
Mm-hmm.
Is parking space 47 really my parking space? And
But I've had it since day one when I moved in here.
I've had it for 20 years, right?
Yeah, exactly.
Exactly. And it's mine. I've used it for 20 years. It's mine. Well, you look at the strata plan to discover that all the parking was actually originally designated as limited common property. And everybody was relatively happy where they were parking, so nobody upset the apple cart. But a new person comes along, buys unit 405 and says, parking spot 32 and 33 are limited common property for my unit. And I want them. And
Right.
he's absolutely right. They're limited common property assigned to that unit, and they're allocated for their exclusive use, and he's absolutely right that they're his parking spaces.
So somebody's going to have to move.
It's like a domino effect.
Interesting, eh?
Because 32 and 33 then moved to something
sure,
else,
of course.
which moved to something else.
Absolutely.
And we've
It's
had
musical chairs in the parkade.
well, it's more like bumper cars in the parkade, I think.
I guess.
But then we have all these people. It's like almost like organizing the deck chairs on a ship.
Yeah.
Everybody suddenly is having to reallocate their parking. And a lot of that has to do because nobody just knew. Nobody had a copy of the documents. Nobody had a copy of the original assignments and
So
the
now,
LCP designation.
as of 2014, a lot of this should become a little clearer to understand.
Well, and strata councils and the property managers are doing a pretty good job about cleaning up their parking problems. They're making their they're putting together parking plans. They're actually getting all their land title documents. They're getting the leases from the owner developer. But it's a big help. It's going to make it much better for buyers.
All right. He is Tony Gioventu, the Executive Director of the Condominium Homeowners Association of British Columbia. I'm Sterling Fox. This is Key Pacific's Talk About Strata. It's a bit of a year-ender. We have mailbag. We've got a lot more emails to get through and some more changes to the rules and regulations for strata owners in our province. More to come. Stay with us.
Delivering relevant and beneficial consumer information. This is Experts on Call. And there's more still ahead on AM 650.